affirm the testimony you're about to provide is true and accurate?
Yes.
Thank you. Mr. Jorde?
Can you please state your name?
Kent Kasischke.
And Mr. Kasischke, do you own land that is targeted by the Summit Carbon Pipeline Project?
Yes, I do.
And do you have three separate parcels in Hardin County that could be potentially affected?
Yes.
And through the course of this matter, sir, did you cause to be filed some written pre-filed testimony expressing opposition to this pipeline?
Yes, I did.
And rather than going through all of those questions and answers, if we were to do that, sir, would you give substantially similar answers here today as are found in your testimony?
I believe so.
And is there anything that you can think of at this moment that you believe needs to be corrected or updated in your testimony?
I don't know of anything.
All right, very good. With that, I would offer Mr. Kasischke's pre-filed testimony and attachments. And I've got them as exhibits 227 and 228.
Are there objections?
There are, Your Honor. We would object to the witness and the pre-filed testimony exhibits. As the board knows, the deadline that was established clearly in the orders was July 24th. There had been some late filed testimony we had objected to. The board had ruled at the outset of this on, I believe, the first day of the hearing on the 22nd of August, to let those in, rather than taking that as warning and the grace of the board. Mr. Jorde apparently took that as license. Mr. Kasischke's direct testimony wasn't filed until September 12th, 7 weeks after the deadline, well after we had any chance to file rebuttal. Effectively, when we were in the hearing and couldn't really spend a lot of time with new material, is absolutely prejudicial. It's wildly in contradiction to the board's scheduling order and requirements. And there will be other witnesses in the same boat. And frankly, there's no reason for it. It's not as if this is a new landowner that called Mr. Jorde and said, hey, I'm interested. Mr. Jorde has represented Mr. Kasischke in survey litigation for a year. So, there's no excuse for it. It's just wildly late and shouldn't be permitted.
So just to clarify, because I thought I caught it looking at the transcript as well, you are objecting to the witness and the pre-filed testimony.
But as a practical matter, those will be the same thing, right? I'm objecting to the admission of the pre-filed testimony and exhibits, without which there would be nothing to testify on.
Just make sure I heard it right. Mr. Jorde, do you have a response?
Well, I do. And this is, I guess, in some ways excellent, because what we would do then is Mr. Kasischke would simply tell you that he wants to proceed as a non-intervening Exhibit H landowner, in which case I would have complete free reign to ask him however many questions I want, essentially, and I'm very happy to do that instead. So I guess I'd leave that up to Mr. Dublinsky, which way he'd like to go forward.
Yeah, and I would certainly give the board more credit than fall for that sort of scam, and I hope that they won't do that, as people apparently want to take that invitation to do that sort of thing. But, there are orders, there are rules, there are procedures. They shouldn't be able to be violated this completely, which I know Mr. Jorde didn't even try and argue. He just said, my alternative is to game the system and figure the board will let me get away with it.
So can you explain why the testimony was filed late?
I frankly, I don't even remember if I assisted with this testimony, so no, I can't explain it. It's not, my testimony, but again, what I would say is he has a legal right as any Exhibit H landowner does, to walk in here and say, hey, I'd like a time to testify. And so if we want to go through that process and he can get on the list in November sometime to testify, is totally fine by me. So
I disagree with the premise there. I don't think anyone has a legal right to simply ignore the procedures of the board if someone came after the hearing was over and said, hey, I happen to be an Exhibit H landowner, you wouldn't have to reopen the hearing for it. There are no rights that are unlimited.
We're going to take 5 minutes to talk about it with the rest of the board. Okay, sorry we are a couple minutes late. I hope everyone understands that's because we take the decision seriously, not because we are wasting time. We've kind of danced around some of these topics now for about 6 weeks. And Mr. Jorde, it's not your testimony. It's Mr. Kasischke's testimony. But he's your client. And it was filed late. And that has been a little difficult to run things a little orderly. But I also don't think it's fair to Mr. Kasischke, who drove this far, to give his testimony. And so we continue to be very frustrated that sworn members of the bar either skirt or come as close to the rules as they can and create challenges throughout the hearing. But in this case, I think Mr. Kasischke has driven too far and been through enough that he should be able to come and be subject to cross-examination and get on with his day in life. So we will admit, we will give the evidence the weight due, and we hope that the parties continue to improve.
Your Honor, while we're at a break anyway, I'd like to just make a record. The same objection will go for Huntoon Farms, which was filed on September 11th. And for the record, frankly, I'm not so sure that it's not Mr. Jorde's testimony. He said he had nothing to do with it, but it has the exact same in as good a location as opposed to in as good a condition as have been in numerous other testimony. I think it's highly unlikely that sheerly by coincidence that would have happened from Mr. Kasischke writing it. But we would make the same objection for Huntoon, although I understand the result will likely be the same.
I can just rule, but you're welcome to acknowledge, or we can just...
Well, yeah, I said I don't remember preparing it. It doesn't mean that it's not similar to other things, so that's all the point I wanted to make.
Thank you, Mr. Dubinsky. At this point, we are... What's that? Oh, okay. I'm sorry, Ms. Coles.
Chairman Howe, I have a question. I have a question. I thought I would like you to give me an explanation why he might not have been able to give his testimony even though it was late. I thought, as landowners, that we had the right, as Exhibit H farmers, to, if we contacted the board or we got an appointment, we would have the right to speak before the board.
Ms. Coles, that is a wonderful question, and I appreciate you raising it. The board, and it's fairly common in administrative law to give very wide latitude to, I want to say pro se, but to non-lawyers, in an interest of making the process more open and easier to become a part of. And it's something that means a great deal to me. But for the lawyers in the room, we spent 3 years learning the rules, learning the process, learning how to help navigate clients through it. And for the lawyers, we do expect them to read the rules and read the orders and follow them. And so when someone has a client or when someone is represented, we run the rules a little tighter. So we're gonna make sure Mr. Kasischke's testimony is in, and he's gonna have an opportunity to be cross-examined by the parties.
I appreciate that because he has spent the time, but I hope this doesn't come up for future landowners.
And Ms. Coles, just to make it abundantly clear, there is not a soul in this room that's frustrated with Mr. Kasischke.
Thank you.
For the record, we have no substantive objections to the introduction of the testimony.
Thank you. Objections are noted. I think we can move on now. Have we tendered the witness?
I don't think we have, and all that I forgot. Did you have any major updates or changes you wanted to make, sir?
No.
Okay, very good. Yep. Then I tender you for cross-examinations. Others might have questions.
Mr. Taylor, would you like to start?
I guess.
Thank you, sir.
Mr. Kasischke, I'm Wally Taylor. I represent the Sierra Club. Can we put up the KMZ file? That's always a good place to start, I think. Does this appear to be your property?
Yes, it is.
Okay. I don't know if Mr. Jorde asked, what county is this in?
It's in Hardin County.
And the sort of diagonal white line, does that appear to be where you understand the Summit pipeline would be located?
I believe so.
Okay. Throughout the process, have you had different impressions of where the pipeline location might be?
No.
Okay. Some folks have said that they didn't know throughout the process where the pipeline would be located, and I just wondered.
That's my first impression as of where I thought it was at.
Okay. Toward the bottom of your property, there's a section there that is in green and has some buildings. What is that?
That is where I live.
Oh, okay. That's your residence?
Yes.
Okay. Do you know how far your house is from the pipeline route?
I would estimate 300 yards.
Okay. Have you had any contacts or discussions with any representatives from Summit about the pipeline location and the impact on your property?
None.
Have they tried to contact you?
They have talked to my mother in the past, and I've never contacted them.
Okay. Do you know what contacts they've had with your mother?
Telephone. That's all I know of.
Okay. Have any Summit agents tried to get you or your mother to sign an easement?
No.
Do you know why they haven't?
No, I don't know why.
Okay. Where would the closest emergency response personnel be if there were a rupture in the pipeline?
Hubbard is 4 miles to the west, and New Providence is 3 miles to the east. And I don't know that either one of them would have the capability of handling a situation like that.
Okay. What do you understand about the risk or the danger of a rupture of a pipeline like this?
I'm not fully aware of all the dangers.
Okay. Why have you not signed an easement?
I don't want the pipeline going through my property.
Did you go to the initial informational meeting that the IUB held in your county when this project was first announced?
Yes.
Okay. Did you talk to anybody from Summit immediately after that meeting?
I did not.
I guess I'm sort of at a loss as to why no Summit representatives would have contacted you or your family about acquiring an easement for that property.
Objection, Your Honor. First of all, I'm not sure there was a question there, but to the extent there was, it calls for speculation on what was in Summit's mind, not what was in the witness's mind.
I'll rephrase it.
Thank you, Mr. Taylor.
Do you have any idea why no Summit representative contacted you about putting the pipeline on your property?
I would guess it has something to do with that. I had a court case in May, and so they didn't do anything while I was being bullied during that process.
In May of what year?
This year.
Okay. Do you know whether anybody from Summit tried to survey your property?
I've asked them to leave numerous times, as well as other people have asked them to leave. No, they have not. I do not believe they've surveyed yet.
Did they send you a notice about surveying?
Oh, probably. I've always returned mailings back to sender.
Okay. Well, thank you. That's all the questions I have.
Ms. Ryan.
Thank you. Good afternoon.
Hello.
I just have a couple questions I want to follow up from your testimony. You indicated that you're the fourth generation farming this land.
Yes,
Do you have plans for it to go on to a fifth generation?
I think so, yes.
Would that be your heirs or another family member?
I have no children, but I have 3 nieces.
And you also indicated that the farm is your retirement plan. So you've been taking it into account in your financial planning for a very long time. Is that right?
Yes.
And you probably have, I'm guessing that if it's your retirement plan, you have long-term plans into the future for it.
Yes, I do.
Would this pipeline interfere with those plans?
I believe they would.
That's all my questions. Thank you.
Thank you, Ms. Ryan. Ms. Colas.
Good afternoon, Mr. Kaczynski. I'm Jean Colas, Colas Family Farms. And I'm extremely concerned about your testimony and trying to understand it. You said you had no contact with Summit representatives, but yet there was a court case with Summit and yourself. Is that correct?
Yes, that was about surveying.
Was it the result of refusing to have them survey your land?
Yes.
And they sued you.
Yes.
So that gave you no opportunity to discuss why you didn't want them on your land.
No, it did not.
You were not able to voice your concerns of what a pipeline on your land could do to it.
No one asked me.
I'm sorry. No further questions.
Ms. Brunegan.
Thank you. Hi. Could the staff pull up his direct exhibit 1? I just had a clarification question. On here, on your southern 2 parcels, it lists a company called Transcontinent Oil Company as a tenant. Do you have tenants on those properties?
I have a cash renter that farms the property.
And is it Transcontinent Oil Company?
No, it is not. I have no idea who that is.
Do you have any business relationship with that company?
None.
But you do have a farm tenant.
Yes, I do.
Thank you. No further questions.
Okay. With no further questions, Mr. Jorde for redirect.
So, in regards to this alleged tenant, that's not a tenant you have or have ever had or are in talks with.
I'm guessing that's something Dad did many, many years ago. I have no idea about what it is.
Okay, but you don't have a oil pipeline or
No.
anything like that, do you?
No.
And you had talked about feeling bullied by Summit through the process. Is that predominantly for the lawsuit they filed against you, or is that just in general?
In general, but my mother received a number of mailings. Here is a 86-year-old widow lady with ill health getting mailings, and she does not even own property. So I assume that is intimidation and bullying and harassment, which all equals into terrorism. My sister has property a mile away from the proposed route. She received mailings from Summit also, and she inquired as to why she was being sent these letters. She was told that since she had the same last name as I do, that it was her job to coerce me into signing easements. And so there again, more intimidation and bullying and harassment, terrorism.
So through your experiences, it's pretty much what you've experienced and been subject to. It's pretty much at any cost they're trying to get you and force you to sign an easement.
Yes.
And that lawsuit that they filed against you back in September of 2022 that had a trial in May of last year, did that cause you distress and also financial sacrifices?
Yes, it did.
And has Summit offered to pay for those costs?
Not to my knowledge.
Has Summit ever told you why the route is what they want it to be, angling across your property?
No.
They never justified that.
No.
Never said why it couldn't hug the boundary of the property or be across the street.
No contact with them.
I don't think I have anything further, sir. Thank you.
Thank you, Mr. Kasischke. Thank you for coming. You can call your next witness, Mr. Jorde. You need a minute? We can do 5 if you need 5.
I think we can probably keep going. If